3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the scientists and tested what the records could actually prove without speculation. Today, we are examining the lawyers and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is Alan Dershowitz's role, as documented across multiple federal filings, where he served as both Epstein's defense attorney and was named by a victim in sworn testimony.
It's a very dense record. And to really get the architecture of this legal strategy, we have to start with the physical baseline. Before any of the filings, before the constitutional arguments even begin.
You mean where people actually were?
Exactly. We have to look at the document titled Epstein's Full Flight Logs Unredacted.
Okay, I have that open. We're looking at raw data here. Just columns, date, aircraft, pilot, passengers.
Correct. And if you scan down that passenger column, the name Alan Dershowitz appears. Not once. It's a recurring entry.
So this establishes presence.
It establishes presence. Now, for a defense attorney, flying to meet a client is, standard. That's not the anomaly here.
But the frequency is one data point.
Yeah.
And the destinations.
That's the key. The frequency and the specific destinations listed in these unredacted logs, they establish a proximity that seems to go a bit beyond a standard retainer.
He was physically inside the Epstein orbit on the private plane.
And the private transit network.
Yeah.
Multiple times. So that's our baseline. Presence is verified. It puts the actor on the stage.
And from there, the documents pivot very quickly away from just travel and into active and I'd say aggressive litigation. We need to look at the Ufrey v. Maxwell case file, specifically case number 15, CV7433LAP.
This is where Dershowitz's role becomes much more complex.
How so?
Well, this is the pivot point of the paperwork. Normally, a lawyer is filing motions for a client. In this case, 15 CV7433LAP, you see Dershowitz filing as an intervener.
Okay, let's define that term based on the text of the filing itself. The document is the reply in support of letter motion for pre-motion discovery conference. What's the legal argument he's making for that status?
The argument is essentially self-protection. An intervener is a third party, someone outside the original lawsuit, who forces their way in because they claim the outcome could directly harm them.
So he's saying the case between Virginia Giuffre and Ghislaine Maxwell is generating material that's about him.
Exactly. He's arguing that the discovery process, the depositions, the emails, all the evidence being gathered, contained defamatory statements about him. He wasn't a defendant in that suit, but the documents show him legally injecting himself into it.
To what end? What was the goal?
To control the flow of information. He's litigating to either redact, suppress, or get access to documents that name him.
So it's not just a defensive move.
No, it's also offensive. At times, he's arguing to force the release of documents that he claims will prove his innocence. The strategy you see in these filings is to actively shape the evidentiary record of a case that he isn't even a primary party in.
And this posture, this aggressive intervention, it leads us directly to the allegations themselves, doesn't it?
It does. We have the source file 2019 AUG 09 court unseals. This was that huge data dump right before Epstein died.
The one that cracked the whole thing open.
Right. And inside that file is the sworn testimony of Virginia Giuffre. We have to be really precise here about what the record says. This isn't a rumor from the internet. This is a deposition given under oath.
And what does it allege?
Giuffre alleges, under penalty of perjury, that she was trafficked to Alan Dershowitz for sexual purposes. She provides context. She names locations. That is the formal allegation that exists in the federal record.
But the record is a binary, isn't it? Because for that sworn allegation, we have a direct sworn rebuttal.
We do. In the file 11 # Alan Dershowitz assorted documents, we have the Dershowitz rebuttal.
And that's just as formal.
Just as formal. Dershowitz filed his own sworn statements. He categorically denies any sexual contact. He attacks the timeline of her claims. He attacks her credibility. He provides his own documentation calendars, emails, arguing that he was never present at the locations she alleges on the dates she alleges.
So if we look only at the documents, we have what you'd call a sworn conflict.
That's the perfect term for it. You have two individuals, both under oath, providing accounts of reality that are completely mutually exclusive. One of them is not telling the truth.
And without a third data point, say a criminal verdict or some kind of forensic evidence, the documents just leave you there in that deadlock.
They do. Except there is a third document. It doesn't provide a resolution, but it does signal a conclusion of sorts. It's the source titled Netflix Alan Dershowitz Drop Claims.
This is about the Filthy Rich documentary series.
Correct. Dershowitz sued Netflix and the producers for defamation over how he was portrayed. This document, it's a news report, but it confirms that the claims were dropped, the litigation was terminated.
But let's audit the text. Do we have the actual settlement agreement in our files?
They do not, and that is a critical missing link.
So we know the dispute ended.
We know the dispute ended. We can assume some kind of transaction occurred, whether that was financial, or a statement was issued, or just a mutual agreement to walk away. But the specific terms are not in the public folder we have. We can't see the receipt.
We know the war ended, but the documents don't tell us who surrendered or what the terms of surrender were.
Precisely. So to summarize the verified record on Dershowitz, we have presence in flight logs, we have active legal intervention to control evidence, we have a sworn allegation of sexual trafficking, a sworn denial of that allegation, and a settled lawsuit with Netflix where the terms remain sealed.
That's what the paper trail proves.
That's the verified summary. Now, we need to zoom out. Dershowitz, as aggressive as his strategy was only one component of a much, much larger legal machine.
The dream team.
The dream team that was assembled between 2006 and 2008 to handle the initial Florida investigation.
Which brings us to a very prominent name, Kenneth Starr. The document Epstein Files Image 003 Index has a simple notation next to his name.
Lots on Kenneth Starr.
And his presence on the team is confirmed in the Jeffrey Epstein Records DOJ full data sets. But the question isn't just that he was there, it's why he was there.
Right. You don't bring in the former independent counsel, the man who investigated President Clinton, just to negotiate a standard plea deal. You hire him for his institutional weight. You hire him to dismantle the prosecution itself.
The documents from the House Oversight Epstein files seem to lay out this strategy. I'm looking at a file with the bait stamp 016552. It's clear they weren't just arguing about facts about innocence or guilt.
No, not at all. It was about jurisdiction. This was their constitutional lever.
Explain that.
Starr and the legal team built a very powerful, very intimidating argument that the entire federal investigation run by the U.S. Attorney in Florida was a violation of federalism.
They were saying the federal government had no right to be involved.
Exactly. They argued that the crimes Epstein was accused of, if they happened, were local, state-level matters. Solicitation of a minor, not federal sex trafficking. They were trying to shrink the case down from a federal felony to a state misdemeanor.
So they weren't just fighting the case. They were challenging the government's authority to even bring the case.
Yes. They threatened to turn it into a constitutional crisis.
No.
The correspondence we have in the House Oversight files details how they went around the line, prosecutors, the people actually working the case, and took their arguments to the highest levels of the Department of Justice in Washington.
And they used the threat of prosecutorial misconduct.
They did. They put the U.S. Attorney's Office on the defensive, arguing that by pursuing Epstein federally, the government itself was guilty of overreach and that they would fight that battle all the way to the Supreme Court if they had to.
Looking at the documents, the audit finding is pretty clear. This pressure campaign worked.
It worked completely. The momentum of the federal investigation just stopped. It was essentially frozen. And the case was kicked down to the state prosecutor's office, who we'll get to in a moment. The documents prove this was a coordinated effort by Starr to use his reputation and institutional knowledge to crush the federal inquiry.
And the result of that was the non-prosecution agreement.
The NPA.
Yeah.
But there is a huge gap in the record here, and we have to point it out. It's often referred to as the secret negotiations.
We have the letters setting up the meetings with the DOJ. We have memos about the outcome of the meetings.
We do not have the transcripts of the meetings. We don't have a recording or a verbatim transcript of Kenneth Starr and the rest of the team sitting in a room with top DOJ officials and dictating the terms of surrender.
So the before and after are documented.
Correct. But the during, the actual moment the government's will was broken, is a black box in this documentary record. We can only infer the pressure from the outcome.
Let's talk about that outcome, the after. We need to analyze the mechanism of the legal shield itself. And to really understand how abnormal this whole process was, we have to start with a document called the Writer Letter.
Evidence Block 3. This is the letter from Michael S. Ryder to Barry E. Krischer, dated May 01, 2006. Structurally, this might be the most important document in the entire archive when it comes to understanding the institutional failure.
So Michael Ryder was the chief of police for the town of Palm Beach.
And Barry Krischer was the state attorney, the lead prosecutor for the county.
So the police chief is writing to the top prosecutor.
Yes, and the context is everything. Ryder is writing this letter after his detectives have spent months building a case. They've done the surveillance. They've done the trash polls. They have interviewed victims. They believe they have probable cause for a major felony indictment.
And he's writing to the prosecutor who's supposed to take that evidence and go to court.
Exactly. Now let's read the specific accusation that Ryder puts in writing.
It's in the second paragraph.
He writes, quote, "It is pretty clear to me that Mr. Krischer did not want to prosecute this case," end quote. He then goes on to describe the state attorney's handling of the evidence as unusual.
Unusual. In a formal letter between the heads of two law enforcement agencies, that word is a siren.
It's a scream. It's a formal indictment of the process. Ryder is creating a paper trail. He is documenting, for the records, this institutional friction. He is stating unequivocally that the police did their job and the prosecutor's office was refusing to do theirs.
He's also saying the evidence supported much more serious charges.
He is. He's directly contradicting the later narrative that the case was somehow weak. The police chief is on the record in 2006 saying the case was strong.
And he attached the evidence to the letter.
He did. He basically said, here it is, look at it. He stripped Krischer of any plausible deniability. Krischer couldn't say he didn't know how strong the evidence was.
But the institutional decision, as you call it, had already been made.
It seems so. The pressure from Starr's federal-level intervention was rolling downhill. The state was now looking for an exit ramp.
And that exit ramp was the Epstein plea deal 2008, the non-prosecution agreement.
This document is the smoking gun. It is the core of the legal shield. When you read the actual text of the 2008 NPA, specifically the immunity clause, it is just a complete anomaly in American law.
It grants immunity to Jeffrey Epstein for any and all federal crimes.
Which is standard in a plea deal. That's the part that makes sense. The part that doesn't is what comes next. It also grants blanket immunity to any potential co-conspirators.
The document says both named and unnamed co-conspirators.
Unnamed co-conspirators. That is the phrase that shielded the entire network for more than a decade.
What does that actually mean in practice?
It meant that the FBI or any federal agency could not investigate, charge, or prosecute anyone else connected to Epstein's sex trafficking crimes in the Southern District of Florida. They had been given a get-out-of-jail-free card without ever being identified, let alone charged with a crime.
So it's a blanket amnesty for a group of people who are, by definition, invisible to the law.
It's a legal force field. It protected the entire infrastructure, the recruiters, the schedulers, the people listed in the flight logs as associates. The architects of that specific clause were the lawyers we're discussing. They didn't just defend a client. They immunized an entire criminal operation.
We should probably bring in Jay Lefkowitz here. His name appears in the Jeffrey Epstein Records Doge full datasets.
He's on the list. Listed as a key member of the defense team, he was another part of that mass strategy.
Overwhelm the local prosecutors with high-profile, expensive D.C. and New York lawyers.
Exactly. It's a classic strategy. You signal that you have unlimited resources and you're willing to make this the fight of their lives.
But do we have a specific paper trail for Lefkowitz, a letter he signed, a specific motion he filed?
And that's the gap in the record for him. Regarding specific correspondence signed solely by Jay Lefkowitz in this particular cache of documents, we don't have that documentation. We can place him on the roster through the DOJ dataset. We know he was part of the team, but we don't have a specific Lefkowitz letter, the way we have the Ryder letter or the Starr correspondence.
So we can confirm his presence on the team, but his specific tactical moves aren't captured in these text files.
Correct. We acknowledge his role as part of that legal firepower.
Okay, so let's move to evidence block 5. The legal strategy didn't just target prosecutors, it extended to the victims, and it was brutal. We need to look at the files related to Sarah Ransom.
Yes, this is sourced from the Epstein file release. 1332-16 Summary of Legal Proceedings. Geoffrey V. Maxwell. The documents here detail a really clear strategy of what we're calling victim credibility tactics.
So Sarah Ransom was another victim who came forward with allegations.
She was. And the defense strategy against her wasn't to disprove the abuse directly, but to try and disprove her sanity, to paint her as an unreliable narrator of her own life.
And they did this by focusing on a series of emails.
They did. They zeroed in on the Ransom Thousand email series. In these emails, which she sent to various people, Ransom claimed she was in possession of videotapes.
The allegations of tapes, this is a theme that comes up again and again in this entire saga.
It is. In these emails, Ransom explicitly claims she has video footage of Prince Andrew, Bill Clinton, and Richard Branson involved in illicit acts.
Okay, but we have to apply our audit rule here. What is actually in the record?
The emails making the claim are in the record. The tapes themselves are not.
So the record proves the allegation was made and communicated.
Yes, but the record does not contain the video evidence she claimed to have.
And Epstein's and Maxwell's defense teams used that absence.
They weaponized it. They went to the judge and argued that because Ransom claimed to have tapes that she never produced, she must be hallucinating or fabricating her entire story. They used her emails as proof that she was unstable.
So they tried to use this one unproven claim to invalidate all of her other claims.
Precisely. They sought to modify confidentiality designations in the case, specifically to get these emails out into the public, knowing it would damage her credibility, not just with the court, but with the public. It's a very specific legal tactic.
It's the fruit of the poisonous tree argument, but applied to a person's entire testimony.
That's a good way to put it. If we can prove she's unreliable on this one thing, they argued, then nothing she says can be trusted. The documents show this was a calculated, deliberate move to suppress her testimony by destroying her character.
This seems like a good transition to the most speculative part of the archive, the part that requires the absolute strictest source discipline, Evidence Block 6, the intelligence narrative.
Right. We have text files in the archive with titles like Epstein Island Operational Reality and Bondi Hegseth Traders. We also have that wiki quotes file that cites Ari Ben-Menashe.
And the narrative woven through these particular files is that Epstein wasn't just a criminal, he was an intelligence asset. The terms Mossad Honey Trap and Unit 8200 appear. Blackmail architecture is a phrase used frequently.
We have to be incredibly careful here. Our job is to be auditors, not to chase theories. The text files making these claims exist in the dataset. That is a fact. We can read them. But we have to ask a critical question. What are these files?
Are they declassified CIA cables?
No.
Are they internal FBI or DOJ memos confirming Epstein's status as an informant or an asset?
No. They appear to be, for the most part, external commentaries, online research compilations, or, uploaded theories. They are not court-admissible, authenticated government documents. We do not have a frantic order from an agency director. We don't have a contract or a payroll record from Israeli intelligence.
So applying our operational rule, what's the verdict?
The claim that Jeffrey Epstein was an active intelligence asset for any foreign or domestic agency is classified as unproven based on the provided source material in this archive.
The claim exists in the file dump, but it is not corroborated by any official record within that same dump.
That is the only responsible conclusion. The government records we have do not verify it.
Okay, but let's separate that from the blackmail architecture, the physical reality of the properties.
A very important distinction. The file, Epstein Island Operational Reality, mentions cameras, recording suites, pinhole lenses. Now, this is a claim we can cross-reference with more reliable sources.
Like the Epstein FBI report from the raids or victim testimony.
Exactly. We have the sworn affidavit of Maria Farmer. She was a victim who lived and worked on the property.
And what does she state under oath?
In her affidavit, she describes being shown a monitoring room. She describes seeing cameras throughout the house. The FBI raid reports from the New York mansion mention extensive and complex wiring, what they call pre-wiring, for audio-visual equipment in nearly every room.
So we have testimonial evidence from a sworn affidavit, and we have physical evidence from law enforcement reports that a sophisticated surveillance system existed.
Correct. The capability for blackmail was documented. The cameras were real. The wiring was real. But we have to make the distinction. The product of that system, the actual tapes, is largely missing from the record. And the management of that system, whether it was Epstein acting alone or for a state actor, remains an inference, not a documented fact.
So, fact, cameras existed. Fact, complex wiring existed. Unproven. Who, if anyone, received the feed from that system?
That's it. We stick to the documented facts.
Okay, let's try to synthesize all of this. We've looked at the individual lawyers, the pressure campaign, the dissent from the local police, the victim credibility attacks, and the unproven intelligence gaps. If we map the timeline, what pattern emerges from the documents?
It's a very clear pattern of containment and then active maintenance. It starts in 2006.
The local system is working as it should. Police Chief Rader is pushing for a real prosecution. He has the evidence.
Then from 2006 to 2007, the lawyers intervene. Starr, Dershowitz, Lefkowitz, the whole team. They don't fight at the local level, they go federal. They apply that constitutional lever to halt the DOJ investigation.
And by 2008, the containment is complete?
The non-prosecution agreement is signed, the shield goes up. It protects not just Epstein, but all the unnamed co-conspirators. The case is effectively killed.
And for the next decade, from 2008 until his arrest in 2019.
That's the maintenance phase. The documents show that the legal shield wasn't just a piece of paper filed away in a drawer. It was an active, litigated enforcement mechanism.
What do you mean by that?
The lawyers, particularly Dershowitz, spent the next 10 years in court fighting to keep that seal tight. Every defamation suit he filed, every motion to intervene in the Jew-free civil case was an act of maintaining the secrecy that was granted by the 2008 deal.
So they built the wall and then they spent a decade patrolling it.
They did. And for a long time it held. It didn't crack until 2019 when a new set of prosecutors in a different district, the SBNY, decided the Florida NPA wasn't binding on them.
So the documents from the lawyers give us the how. They show us the specific mechanics of how the justice system was disabled in Florida. We have the flight logs placing them on the scene. We have the plea deal they authored. We have the police chief's letter exposing the irregularity of it all.
We have the conspicuous gaps in the record. We have the missing negotiation transcripts and the missing tapes.
It leaves us with a final provocative thought. The American legal system is adversarial. It requires two sides to function, a prosecution and a defense. The documents show that one side, the defense, was staffed with some of the most powerful and politically connected lawyers in the country.
And the other side, the prosecution, both at the state and federal level, folded. They folded against their own protocols and against the documented evidence provided by their own police investigators.
So the record leaves the question open. Was this non-prosecution agreement a brilliant legal victory for the defense?
Or was it a complete institutional collapse on the part of the government? The documents don't give us a motive. They just show us the signatures of the men who signed the deal.
And the names of the men who built the shield that let so many walk away free.
For a time.
Next time. The bank.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.